Good afternoon. Please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is case number 01-22-00706-CR, John Desmond Crawford versus the state of Texas. Starting with appellant, will counsel please make your announcements?
Hi, my name is Susan Clothier, counsel for the appellant, John Desmond Crawford.
Okay. Natalie?
Megan Callahan, counsel for the state of Texas, the appellee.
Very good. Each side this afternoon is going to have 20 minutes for argument. As you know, I think you've already said, but appellant, do you wish to reserve any time for rebuttal?
Yes, sir. 5 minutes, please.
Okay. Before we begin, I got a couple of housekeeping things. The lights, you probably argued, another appellate courts, green, yellow, red. Green obviously means start. Yellow lets you know there's 1 minute to go before the red light goes on. When the red light comes on, if we're asking you a question or you're in the middle of answering the question, please finish your answer. You don't have to stop it instantaneously. And then once you finish your answer, then stop unless there's some other questions that may come from the bench. Also, we don't need a recitation of the facts. In this case, we've read the briefs, we've read the record, and we're familiar with underlying facts. So it's most helpful to us if you all could just dive right into the legal issues. With that in mind, we'd ask the parties to begin their argument today on the issue of custody. So with that out of the way, we're now ready to proceed to hear from counsel for appellant.
Thank you, Your Honor. May it please the court, I was actually planning to start with custody anyhow. The first things first, I do want to address the question of preservation of error. It was raised by the state, and I felt like it was worth raising just as, first issue. We can see there was no pretrial suppression hearing, but the counsel did object at trial. At the time, the state had tried to admit the evidence of the confessions. So that was in the 6th volume of the reporter's record on page 16. This court actually not that long ago, about 10 years ago, did address in Connor v. State kind of a similar situation with a little bit distinguishable facts where there was no pretrial suppression hearing, but this case, the defendant's attorney did not raise the issue until the motion to, after the close of the evidence and trying to get a directed verdict. This court had noted that was not timely as far as preserving error. So in this case, it's not the same thing because he did object at the time the evidence was coming in, and we do not have findings of fact, so that does change the standard a little bit because we do have to look at all the facts in the light most favorable to the state and the court's findings and rule, only, look kind of like a summary judgment. So I'd like to just jump right into the custody situation. The question is really, did it become custodial, and if so, when, and at what point should that have triggered the warnings under Miranda on Article 3822? Something to note, and I think this is really important, is when the Supreme Court of the United States changed the standard to remove the subjective and the subjective review, and it's only looking at the objective reasonable person standard. So, in this case, there were actually 2 separate interviews, 2 days apart. And the first interview was at the police department in Hearn, which is not a neutral place. That's mentioned in many cases about whether it was at their home, was it at the police department. And the detective had actually already conducted the investigation, done the forensic interview of the younger complainant, HL, and had more than probable cause. The question is whether or not a reasonable person would have believed there was probable cause to arrest at that time.
Ms. Cloutier, may I ask you something? What, if any, role does Mr. Crawford's possible intellectual disability have here in terms of the subjective-objective question?
I actually believe that his intellectual disability is irrelevant in the sense that we're not looking at his subjective belief, we're looking at a reasonable person's belief. So we have to take out his intellectual disability and look at what an average reasonable person would have thought. So while maybe Mr. Crawford, in the situation of being called down to the police department, admitting to a first-degree felony, I think the reasonable average human being would know at that moment that they were probably going to be under arrest for that felony. He unfortunately didn't have the capability to form those connections, but because the Supreme Court has mandated that we look at it from an objective standpoint, if anything, his intellectual disability really just helps bolster our point, is that a reasonable person, having admitted to having intercourse with a 15-year-old girl, would immediately believe that they were subject to a criminal investigation. And in that particular situation, he did not actually admit to anything with the complainant that he was indicted for, which is the 13-year-old HL. It was 2 days later he returned for the second interview, and he had some correspondence via email with the investigator, and there was some questions about, well, why are you just taking action on this? Am I going to county jail? The states, did mention a lot in their brief about, well, that's just locational. But when you're looking at a reasonable person coming back for a second interview, that is also not at like a neutral place. So it's at the Criminal Investigation Division investigation room.
What do you make of the fact that he was told he was free to leave at any time at the first interview?
So at the first interview, he was told he was free to leave, but subsequently the officer asked for consent to search his vehicle, to basically photograph it. I think a reasonable person at that point would believe they're subject of an investigation. The fact that he physically did leave isn't really necessary to the inquiry, because the inquiry has to do with at what point during the actual interview did it turn from non-custodial to custodial. So, I think there's a good argument that occurred during the first interview, but at the very least it occurred during the second interview, which lasted 5 hours. They were, using coercive techniques. They brought in an extra investigator from out of town who was, an expert in getting confessions. And very hours into the interview.
Did Mr. Crawford know that person was an expert in eliciting confessions?
I don't think it was in the record whether he knew that, but again, we have to look at the objective. Would a reasonable person have known that? And based on the investigator's testimony at trial, she explained, and it's in the record, a lot of the investigative and the questioning that she uses and the strategies to elicit a confession. If it were a reasonable person, they probably would have at least understood that they're in trouble. He may not have, but I don't think it matters, because again, it's an objective look at what a reasonable person would have believed in that moment.
Didn't Mr. Crawford, didn't he initiate the second interview though? The first interview was done, 2 days had passed before the second interview, and he had actually initiated it, correct?
He did. He voluntarily showed up at the second interview. Both interviews. He did not, there was no arrest, there was no handcuffing. We're not trying to argue that he did not show up involuntarily. What we're arguing is that the confession became inadmissible by the point in which that the interview became custodial.
What point is that it became custodial, in your opinion?
I believe the moment that he believed that it was made very clear to him that they were investigating this crime, and when he admitted, and case law is pretty, it's kind of a little bit all over the place as far as how to interpret that when you're dealing with an admission, but where it all started with Douthat in 1996, when a suspect admits to the offense in the actual interview, and a reasonable person would realize that incriminating nature of the admission, that's when the court has to start looking to the other factors to determine whether or not that became custodial. There's a case, Zhu versus State, it's a Fourth Court of Appeals opinion from 2002. When I didn't cite it, so I'll mention it's 100 Southwest 3rd 408. And in that case, it's actually similar. It's not binding, obviously, but this one, he arrived for a second interview voluntarily, and he made a pivotal admission during that interview. At that time, probable cause was established, and the court found that a reasonable person would have realized the incriminating nature of that admission, and that certainly the police had no doubt. Other circumstances they found...
So let me just cut you off there, I apologize.
No, you're fine.
So going back to her question, Justice Landau's question, so what point here is your position, it's hard for me to tell from the briefs, are you contending that this became custodial? At what point?
I think you could easily find that it became custodial at the end of the first interview before the second, despite the fact that he did show up for the second without prompt.
So what part of the end of the first interview?
At the point in which he admitted to having sexual intercourse with a 15-year-old, a first-degree felony, and then, upon that point, the police asked to...
And is that because it would have demonstrated probable cause?
The way that the cases kind of say, it's either that the police officer has to either tell the suspect that there's probable cause, or the suspect has to tell the officer something that would lead a reasonable person to believe there's probable cause.
Is probable cause
that he committed an offense
enough all by itself to trigger that component of the test?
I think that the facts are really important to look at, because there's a couple of cases that do go the opposite direction. One out of this court, that is Rankin versus State in 2020, but they said in that case the probable cause wasn't enough, because even though the person being interviewed admitted to causing the injuries, the detective did not believe the story was plausible or that it was complete. So it's more the unequivocal confession as to a first-degree felony, and then all of the acts afterward where the police are, wanting to search his vehicle, taking photos. He probably... Did that
happen afterwards? Or?
That was during the first interview.
Was that before the end that we're
after the
talking
confession?
About? Okay.
I think a reasonable person in that position would know they were most likely going to be arrested in that time. Now, he was not.
I'm sorry, during the first interview though, the confession was concerning the 15-year-old. It was not
Correct.
Concerning the complainant here.
Right.
So we need to look, don't we not, at the confession as it concerns the complainant in this case, and that did not occur in the first interview.
That is correct. I don't believe that the analysis, though, when you're determining whether it's a custodial or non-custodial interview, has to do with which complainant the state ultimately decided to indict on. Because the crime that he admitted to in the first interview could have been indicted. I don't know the reason why the state chose not to. Very well could be because of the fact that that occurred prior and they were possibly feeling that they would not have been able to introduce that evidence. I don't know. But during the second interview, that interview went way longer, 5 hours. It was a lot of repeated questioning. Now, it is important to note some of the cases say they look to, well, did they give him drinks and water and bathroom breaks? They did give him all of those things. But at the same time, they asked him to write apology letters. They asked him to draw a picture of his hand and indicate how far his fingers had inserted into the complainant's vagina. So those things are typically kind of in line with, like, okay, here's write down the confession, which courts have found that typically indicates they're under arrest. And the case I was referring to earlier in Zuby State, they did not actually arrest the individual during the admission. He was free to leave the interview. He left the interview, but the court still found that at the time of the pivotal admission, the interview became custodial. So I think
but
really...
in that case, was the admission in that case the complainant in the case? I mean, unlike here, right? Because here the admission you're talking about was about somebody else.
I do believe that you're correct on that, but I think that when you're dealing with just the pre-trial, pre-indictment conduct of an interview with the police officer, if they had chosen not to indict, I would still say that you could say that the interview was custodial. I don't know that it would matter, but I don't think it makes any difference which offenses they chose to indict. It was really just the matter of, at that time and place, did that interview become custodial by the way that they were handling the questioning. And, you know, I do think it's unfortunate to do an end run around the Fifth Amendment in the sense where, you know, maybe taking advantage of his intellectual disability, knowing he would go along with all of these things, not knowing what a reasonable person would know, but we have to look at it from the perspective of a reasonable person.
I think we might need to move on to the issue of the multiple outcry before we.
Yeah, I'm happy to do that. I think with this, I can kind of breeze through it a little bit. The 3 outcry witnesses that testified essentially testified to basically the exact same events. You know, I think that there's some question about whether or not the first outcry witness, which was the woman from the church, she said that HL had told her she had been raped, which the state has indicated that means intercourse. But the Texas Penal Code section 22.011 does not define a word rape. They call it sexual assault, which includes intercourse, you know, improper touching, penetration digitally. So when she said rape, that's just a non-descriptive way of describing the events in the indictment. So maybe she shouldn't have been an outcry witness at all.
Let me move you even further forward.
Yeah.
If we agree with you that at least one of those witnesses was cumulative or error to admit their testimony, about the harm analysis under 44.2b, does it operate the same here in a multiple outcry error as it does in other errors, or is it different here? Can you explain that?
I think that in the way that it's different, I mean, certainly it's under 44.2b. I mean, it's a non-constitutional error. It has to be using that same standard. But because of the fact that any type of sexual assault case depends entirely on the credibility of the witnesses, in cases like here where there's no physical evidence, when the credibility of the witnesses is the question before the jury, cumulative evidence that is inadmissible is highly prejudicial. And especially if this court does find that the interviews were custodial and that admission should not have been entered, there would have been no other evidence to corroborate the statements.
Is it always the case under our law that if a complainant testifies to the same information, this error with multiple outcry witnesses is necessarily harmless?
I don't have a case in front of me that says that exact thing, but I think because of the fact that her credibility was the central question that the jury had to decide, you know, bolstering her testimony with repeated outcry witnesses, which is clearly an error. I think that could sway a jury, and it could fall under the 44.2b harm analysis, and that it could have had a substantial impact on the jury's outcome, especially in sentencing. But especially with the cumulative effect of I'm way over. I do want to stop.
That's okay.
You finish your.
Okay. The cumulative effect of both errors, which of course the first being a 44.2a analysis. There's no beyond a reasonable doubt that it didn't cause improper jury verdicts. I think putting those together certainly find that he needs to have a new trial.
Do you have any further questions?
No.
On the bench? Okay. Well, your time is up. We appreciate your argument. Thank you very much. We're now ready to hear for the appellee.
Good afternoon, Justices. Starting with the first issue, the appellant would have you believe that once probable cause is established, at that moment, the interview must stop and Miranda must be read. They rely on Ruth v. State, which has been modified as indicated and dealt with Zapata, which is an opinion written by this court, and by Stansberry, a Supreme Court case. And as she said, they removed the subjective element. And what they had held is, unlike an appellate's brief where she said PC may be manifested to the defendant, the case law actually says that PC be manifested to the defendant, and there's a big difference. Additionally, in dealt with, the defendant bears the initial burden of proving custody or bringing that issue up. As she stated, there was an objection when the confession was entered into evidence, but it was as of to the redactions. There was no objection to the confession as it relates to custody until after the entirety of the confession was played to the jury. A person is in custody only if a reasonable, innocent person in the same position would feel restrained. And there's 4 different versions of custody. The first 3 relate to physical restraint of the physical movement, and the 4th relates to the probable cause. Since the appellant focused on the probable cause element, I will as well. For probable cause, you have to look to all the factors to determine whether that probable cause has been manifested to the defendant.
Let me ask you a quick question while
Yes.
I'm going through that. When we conduct this analysis, do we look at it, the interviews together, or do we look at each interview separately to determine whether there was custody?
I think that under either analysis that the result is the same, that you'll determine based on the factors that he was not in custody. The factors that you look at are set forth in Urban v. State, which is an opinion that was written by this court in 2010. In Urban, the factors were voluntariness of the arrival of the interview, the length of the interview, access to friends and family, and the degree of control exercised by law enforcement. In this case, in the first interview, Mr. Crawford arrived voluntarily at the request of law enforcement. The second interview, he requested via email to do a follow-up interview because he wanted to speak to officers again. He was also allowed to leave at the conclusion of both interviews. He does make the assertion, am I going to the jail? That's the only thing I see on the map that's close to that address.
At what point does that occur?
That is when he is trying to set up the interview with the officer. He requests the interview. The officer tells him it's at this address, and he says, am I going to the county jail? That's the only thing I see on the map close to that address.
Isn't that building, though, doesn't it contain the police station and the jail?
It does indeed. It includes the entire Justice Center, the Sheriff's Office, the jail, and the Justice Center where we house our courtrooms as well.
So it's a little bit unclear, the nature of the question, given that he might be asking, am I to drive to the place where the jail is versus am I going to be arrested?
Yes. At the beginning of that interview, though, he was told on several occasions, you are not under arrest, you're free to leave, the doors are not locked behind you. And additionally, the length of the interview is actually 4 hours and 53 minutes. The last few minutes of the interview is just blank time, even though it does go over the 5-hour mark.
Is this the first interview or the second one?
This is the second interview. In the second interview, at 4 hours and 20 minutes is when he begins writing the letters, and there's nothing really of substance regarding the interviews at that point. In this court, in Zapata, quoted several different cases regarding the length of time, which appellant said that I refused to, or I did not address in my brief, so I'd like to address that now. In Meek, they held that a few hours, voluntary presence, and unsupervised access to the car was not custody. In Urban, 4 hours at the police department during an interview was not custody. In Douthwood, they said 6 hours holding at the police office was a factor in determining custody, among the fact that it was a 13-hour total interviews, 3 back-to-back interviews, a polygraph exam. He was denied access multiple times to see his wife and family, and he was also arrested on that night. So that case is much different than the case before us here today.
What role does your consent form play in this case in determining whether the interview was custodial or not? It seems like the consent form contains some of the rights enumerated in Miranda, but not all.
So the consent form is something that's established by the Texas Department of Criminal Justice. It is them telling the defendant they are going to be trying to do this test on them, and are they consenting to the test? Not necessarily the qualities of Miranda, but it does include the right that you're here on your own free will, you're under no duress, you have the right to leave the interview at any time.
Was there any indication that we could find in the record that Mr. Crawford understood the consent form as opposed to just signing it?
Miss Salazar actually went back and she asked him, what this says is you understand you're here on your own free will. He said yes. You understand that you don't have to be here. And he said yes. She actually went back to make sure that he understood that consent form.
Wasn't that after he signed it though?
Yes. I believe that's correct, Justice. I would have to rewatch the video, but I think that you're right. But she did go back and make comments several times that he understood what he had signed or was about to sign. Another thing is the degree of control exercised by law enforcement. The appellant was given water, mints, restroom breaks. He was never placed in cuffs. He was never told he was under arrest. In fact, the interviewer, Ms. Salazar, had no gun and no handcuffs on her person. She was a plain dressed investigator with none of those things. A pivotal admission in an interview doesn't mean you automatically have to stop the interview and read Miranda. You have to look at everything. And in this case, in Rankin v. State, Judge, that's an opinion that's drafted by you, Justice Landau. This court held that the defendant was not in custody after she made a pivotal admission at the hospital regarding a murder. And in that case, she was handcuffed and transported to the police station for questioning. At the end of that, the court in that case also determined that the handcuffs were a part of police policy regarding transportation and why that was okay. Both officers that testified in that case said that Rankin was free to leave, and this court held that custody is established if the manifestation of probable cause combined with other circumstances would lead a reasonable person to believe that she is under restraint to the degree associated with arrest. I would argue to you that Mr. Crawford and neither investigator in this case, neither told him he was under arrest. No one said he was not free to leave. And in fact, he was allowed to leave at the conclusion of both interviews.
So to be clear, more than just simply understood appellant's position, it was the manifestation of probable cause that was the key factor here that turned this investigation or turned this interview into one that was custodial. Your argument is that the manifestation of probable cause alone doesn't pass that, doesn't rise to that level, doesn't clear that hurdle, right?
I think what you're asking, Justice, is what I'm saying is there was no manifestation by law enforcement of probable cause to the defendant that he would feel that he was under arrest.
Or if he felt objectively, if he knew what probable cause was.
He never conveyed that to the officers, that he felt that he was under arrest.
That's not a requirement though, is it?
No ma'am, I'm sorry, Your Honor. That's not a requirement, but that was never said by the defendant either in this case. In Shiplet v. State, which is the Texas Court of Criminal Appeals case, it was a murder investigation of a law enforcement officer. And as a law enforcement officer, they know how the laws work. They determined that the focus of custody, even though he knew he was the prime suspect, did not make him in purposes of custody. They also said that after he failed 2 polygraphs and was transported to the second polygraph by law enforcement, that was also not custody. The defendant also gave oral and written statements at the conclusion of the end of the second polygraph that the defendant knew he failed, and they found that that was not custody. The subjective belief by the defendant that he was under arrest was not custody, because in that case he said, I know I'm guilty, you can just take me, and they found in that court that that was not considered custody either. Regarding the outcry witnesses, it is a well-established law that a child victim's uncorroborated testimony is enough to support a conviction. The case and the statutes allow us to bring witnesses to testify in those cases when the child is under 14 years of age. A court only abuses their discretion if it's outside the zone of reasonable agreement, or the court acted arbitrarily, unreasonable, or without reference to any guiding principles. Those cases are held on an event-specific and rather than a person-specific. So what does that mean? An event, you could have this 2 separate offenses, and those are 2 separate events. Even though they happen to the same child, Those are two separate events. Let me give you an example. In Josie v. State, there was two outcry witnesses. One was the mom, and one was the forensic interviewer. The mom testified that the daughter had told her that the defendant stuck his tongue into her vagina and he fingered her. The court determined that the mother was the proper outcry witness as to the oral sex, but not as to the digital penetration. The child was forensically interviewed, and she told the forensic interviewer that he had penetrated her vagina with his fingers. And the court found that the forensic interviewer was the proper outcry witness as to digital penetration. So even though it was the same child, it was two separate events, two separate acts, therefore two separate outcries were appropriate. In this case, we would argue that similar facts. The mother was the proper outcry witness as to the digital penetration. The child told the mother that he inserted his fingers into her vagina. She told the forensic interviewer that he had stuck his tongue into her vagina.
Wait, let me stop you there.
Yes, ma'am.
Did the complaining witness not also tell the mother about other aspects of the assault? Digital penetration, oral sex, and sexual intercourse?
She did not tell the mother that he had inserted his tongue into her vagina. She said he put his tongue on her vagina, which are different crimes. One is an indecency with the child, while one is aggravated sexual assault of a child. Additionally, in our case, Hannah, the victim, also testified as to the digital penetration and the oral sex. In Duncan v. State, which is quoted by Berg, it says, any error in admitting evidence is cured where the same evidence comes in elsewhere without objection. We would argue that because there was no objection to Hannah testifying as to the oral sex and digital penetration, that any harm that you determine would exist is cured by the fact that there was no objection by trial counsel as to Hannah's testimony in that case.
What about the firearm? She didn't testify about that.
The victim did say that he had a gun on his person.
Okay.
Yes, ma'am. This court.
I'm sorry, did she testify as to that during trial, or did she tell that to Ms. Martinez, who then testified about the gun?
Both. On August 31st, 2023, this court, in an opinion authored by Justice Rivas Malloy, the court issued Berg v. State. That was an opinion that was written and published after the appellant's opinion. In that case, there was a forensic interviewer that testified to extraneous offenses regarding the victim. This court held in that case that because those were admissible under 3837, that there was not harm in that case. They did say that the court abused their discretion in allowing the outcry witness to testify to the extraneous offenses. But because the victim in that case also testified to those offenses, that complaint was cured.
So is it the case that if the complainant testifies, there can never be harm in a case like this, even if there's error?
I would argue that if there is no objection as to her testimony.
What would the objection be? A good objection. What would that be?
That it's duplicative of other testimony, Your Honor. But that's what this court and the Texas Court of Appeals have said in Hudson v. State, that any error admitted without objection cures a complaint in that situation.
What about the argument that Ms. Clouthier made that in this case where credibility is essential, and sometimes the credibility of the complainant is the key that the jury is determining, when you have outcry witness that in fact is bolstering, as they argue, the credibility of the child or the complainant in this case, then maybe we need to look at something else other than the cumulative nature of the evidence when we're analyzing harm.
I think that again, in Berg, they found that the cumulative evidence was in fact one of the reasons it was harmless, because it was duplicative of the same testimony that was brought in without objection by trial counsel. In our case, Hannah did testify to the sexual assault in which the defendant inserted his penis into her vagina. The very first question in that was objected to by trial counsel as being an extraneous offense. The state then went on to elicit 8 pages of testimony regarding the sensory details of the sexual assault between the victim and the defendant. And as noted in Berg, they note Brown v. State, which is another opinion drafted by this court in 1985. And they held that it is defense counsel's responsibility to object every time alleged inadmissible evidence is offered. And while counsel objects to certain inadmissible evidence, but then permits similar evidence to come without objection, the complaint is deemed cured. And in that case, there was an extraneous offense as well. And they objected to the very first line of questioning. After the objection was overruled, there was no further objections made by trial counsel, and that's what they held, that everything after that first objection, because there was no running objection, there was no objection outside the presence of the jury, and no contemporaneous objections, that any complaint on that was cured in failing to object. In a sister court in 2013 in Carrillo v. State, which was cited in my brief, it was a continuous sexual assault of 2 girls. And they also allowed an extraneous offense pursuant to 3837 and an extraneous offense outcry. That court in that case held that the court abused its discretion by allowing the outcry as to the extraneous offense, but that any harm was cured or was deemed harmless because of the substantial evidence giving the defendant's confession, the testimony by the victim, and the testimony by other parties. And so we would argue that in this case, this is less egregious because we're not admitting an extraneous person. This was, in Carrillo, it was an extraneous person and an extraneous offense. In our case, it's just an extraneous offense that was timely disclosed under 3837. The appellant in their outcry brief regards Nino v. State, and that's where their argument relies, regarding the improper admission and abuse of discretion of outcry witnesses. If you look to that opinion, they did find that it was an improper outcry witness, but that it was harmless error. So even their own opinion deems it harmless.
Did they explain why, Nino, why it was harmless?
Yes, Your Honor. The mom was the proper outcry, not the forensic interviewer, because though the details given to mom were limited, it was clear that they could determine the nature of the indicted offense. And so she was the proper outcry. So for those reasons outlined, we would urge that the defendant was not in custody for purposes of Miranda in neither the first interview or the second interview. He arrived voluntarily. He was never arrested. He was always free to leave and is allowed to leave, and there was no manifestation of probable cause by law enforcement to the defendant. Regarding the forensic interviewer and mother, regarding the digital penetration and oral penetration, we would argue that that is not an abuse of discretion because they were accurate outcry witnesses as to what they testified regarding. And if you do determine there was an abuse of discretion, that it's harmless. And finally, regarding Ms. Conrad, if you determine there is abuse of discretion, based on your holdings in Berg and your sister court's holding in Carrillo, we would urge that it's a harmless and it was not harmless in Mr. Crawford's case, or it was harmless in this case. Thank you.
Any more questions from the rest of the panel? Thank you very much. We appreciate your argument. We're now ready to hear rebuttal from the appellant.
Thank you, Your Honor. May it please the court. I'd like to start with the outcry witnesses. I think one of the issues that I think the state might be conflating testimony of the actual complainant, HL, versus with the testimony of the outcry, we did not object or lodge an objection to the testimony of the complainant. We are arguing that there were 3 separate outcry witnesses that testified to the same event. And for the court to adopt what the state suggesting, which that being raped is an extraneous offense, would simply, we'd be having to reject section 22.011 of the Texas Penal Code, because the state of Texas does not define the word rape as intercourse. The statute says that it includes intercourse, penetration, sexual contact with a minor. All of the offenses that were charged fall under that statute. So the vague reference to rape was not, it could not equivocally have been an extraneous offense because it falls under the statute the way it's defined. And the actual testimony of the outcry witnesses is so similar. And I actually have the quote of the mother, and she did say oral sex. At the time, she said that she had taken her shirt off, had put his hands down her pants, put his finger inside her vagina, that he performed oral sex on her. Well, she wasn't sure what that was about, just that he put his mouth on her vagina, and then he fondled her breasts a couple of times. And the language that Marilyn Martinez, the forensic interviewer, she told me that Desmond had pulled down her underwear. After this happened, he started putting his mouth on her vagina, put his tongue inside her vagina, which obviously is the same as oral sex. She told me that he bit her vagina several times. Now that's different evidence or different information that still falls under the same offense, so it wouldn't be necessarily different and distinct. And then Todd mentioned that sports bra, when it happened, she told me he squeezed her boobs under her sports bra and told me that it was hurting. She told him to stop. That's almost identical testimony. It is not distinguishable. They're both explaining the exact same events. And then with that on top of the church, Ms. Conrad basically much more vaguely referencing the events, but still the same 3. So having not 2, but 3 separate outcry witnesses.
I think you said, let me interrupt right there. So I think you said during your initial argument that the error that you complain of here with respect to the outcry could be harmful. Could you go through, explain your harm argument for us?
Sure. So the, in cases such as this, where there's the credibility of the complainant is the main issue, and also the credibility of the defendant. So the jury's the sole judge of the credibility of the witnesses. There's no physical evidence. So, even with him admitting, there was evidence in the record that he was intellectually challenged, and there's ample information out there that intellectually challenged people often make, confessions to things they did not commit.
Did you brief any of that? Or
no, I'm just saying, just in the record, but
okay.
Just in general with the harm is that because, and this is throughout much case law, that when credibility is at issue, bolstering the credibility by providing inadmissible hearsay with multiple witnesses, it could sway the jury if they were on the edge. And so I do think that we cannot be certain that it didn't have an impactful influence on the jury, that he needs to have a new trial to ensure fairness and justice on that issue.
Do you have a case where the complaining witness testified to similar or same information as an excess outcry witness, and that was found to be harmful?
There is, it's in our brief. I don't have one right here.
Okay.
But I'd like to mention too that the state did kind of go into a lot of what occurred at the interviews regarding the whether it was custodial, but mentioning a lot of information that is simply subjective. What he thought, what he did, and what the police said and did. We really can't look at it subjectively. We have to look at it from all things on the perspective of an objectively reasonable person. So I think that's important. And also, I did not mean to say the pivotal admission alone gets us there. What this case law says is when we get the pivotal admission, that takes us to kind of step 2, which is looking at the other parts, other factors such as length of interrogation, officer's actions. And the case that the state cited about how the length of the interview was not at issue. Do you mind if I finish my sentence? Okay. The court did indicate that based on the fact that it was a capital murder and there was a lot of details, that the length was necessary. Where here, almost 5 hours with very simple facts, the length would be treated differently. So unless there's any other
Thank
questions.
you, counsel. Do you have any other questions on that? Thank you very much. Your time is up.
Thank you.
Thank you both sides today for your argument and for your briefing. It was excellent. And with that, this case is submitted and we are adjourned. Thank you all.
All right.